John Rust removed from the ballot, limiting debt protections, plus the latest twist in the 13th check debate, and more. From the television studios at WFYI, it's Indiana Week in Review for the week ending March 1st, 2024.
Indiana Week in Review is made possible by the supporters of Indiana Public Broadcasting Stations.
This week, Southern Indiana egg farmer John Rust was removed from the Republican primary ballot for U.S. Senate in a unanimous decision by the Indiana Election Commission. The Indiana Supreme Court also ruled against Rust the same day, reversing a lower court decision that would have kept Rust on the ballot. State law requires candidates in a party primary to either have voted in that party's primary in the last two primary elections in which they cast a ballot, or get the permission of the county party leader where they live. Rust doesn't meet those requirements and argues it's an unconstitutional requirement to get on the ballot. Rust's attorney repeated those arguments before the Indiana Election Commission, urging its members to keep Rust on the ballot. But Commission member Karen Celestina Horseman says the board's hands are tied.
Indiana Supreme Court has spoken to us, and they've told us to enforce the law as it was originally written.
That was already true before Tuesday's Election Commission hearing. The Supreme Court had temporarily halted the lower court's decision that had allowed Rust on the ballot, and then, minutes after the Election Commission's decision, the Supreme Court issued a new order saying it had voted against Rust. The Rust campaign is appealing the Election Commission's decision and continuing its ongoing legal battle. Was this always where the Rust situation was headed? It's the first question for our Indiana Week in Review panel. Democrat, Elise Shrock. Republican, Mike O'Brien. John Schwantes, host of Indiana Lawmakers. And Niki Kelly, editor-in-chief of the Indiana Capital Chronicle. I'm Indiana Public Broadcasting Statehouse Bureau Chief Brandon Smith. Mike O'Brien, does this situation prompt lawmakers to revisit this relatively new two-primary rule?
Maybe, but not because we have to vindicate John Rust, right? I mean, no one's going to go storm to the State House next session and try to seek justice. But I also didn't love in the Election Commission the remedies that were said to be available to them either, where we have a situation where one of 92 county chairmen can challenge on this basis. Well, you could have moved to another county with a friendlier county chairman. It's like, well, that seems like a pretty high bar.
And also, as someone on the commission mentioned, that's also called carpetbagging in a lot of places.
Right. Yeah, right. Now and you're running for statewide office, but this process is designed in most cases to keep people on the ballot. It's 2-2. It's 2 Republicans, 2 Democrats. It's designed to split. In these situations where you're trying to pull somebody off of the ballot, except in this case, in this 2 primary requirement that the legislature passed not too long ago. They had a one party requirement or one primary requirement prior to that, which I used as a county chairman to keep people I knew to be Democrats off the ballot. And now, if they wanted to get involved in Republican politics and vote Republican in the next primary, then then you've met the threshold, and that's not that big of a deal. It's 18 months. 2 has problems like this, where now you're forum shopping for a friendly county chairman to keep you on the ballot, or
if that's even an option, if you're just
or you're disqualified to run for office because you didn't have 2 primaries available to you. You're a 21-year-old running for school board,
or you just moved Indiana. Heck, you could have moved Indiana nearly 3 years ago. But if you weren't able to vote in the primaries,
right.
I mean, in the case of Rust, they pointed out, Elise Shrock, that he lives in a part of Indiana where he doesn't even have municipal elections to vote for, so he wasn't available in 2023. That might have made the ballot. So, I mean, does this rule need revisiting?
Possibly. I mean, I'll also remind folks that this was passed in a Republican supermajority, and we're seeing it play out in a Republican primary. Not that surprising. Probably, I think this election committee was packed with all types of hearings. It was wild. The fact that we are paying this much attention to an election commission meeting is kind of unprecedented.
Except when Marlon Stutzman sued Todd Young with the Democrats in 2016.
Fair. I mean,
that was the exception.
But this one has been a bombastic. I mean, we've got the Supreme Court involved. Yeah. The timing has been really wild. And I think, yes, maybe we can look back at this. I think in the grand scheme of things, is this going to affect the way that the Senate race plays out on the Republican side? Probably not.
Yeah, even if Rust had made the ballot or
The
somehow
question is he
through
going to
his
run a
win-
campaign now? Is he just going to keep these legal challenges in case one of them hits? Is he going to? But I mean, he can't appear on the ballot. So at some point, it's like I'm appealing and running this campaign and driving my bus around.
I
It's
mean,
like,
literally
well, at some point
within-
we got to print ballots and start
Exactly.
voting.
I mean, and that's
right?
going to start happening like next week.
And
Oh yeah,
also say,
we're in
these-
process of certification well before early voting starts.
Whether or not it's the Republican Party or the Democratic Party, these like inter-party kind of like squabbles that happen, it doesn't necessarily change the outcome in that election, but it does tend to spur animosity that you can see last over a longer period of time. So I think I'm not sure this is going to change anything in the short term, but it may have a long-term effect.
I mean, watching that whole election commission hearing too, though, I mean, it was a dozen people who were kicked off the ballot for the same reason, over and over and
Yeah,
over again.
14 people were kicked off the ballot, most of them under the two-party rule. And to be
Two-primary
fair, two-primary rule, it was done by Republicans and Democrats.
Absolutely.
And for the most part, it was to stifle competition for an incumbent. And, you know, I wrote something about this today, and I don't have any problem with the one primary rule. I do think the parties have a right to make sure that a candidate is, you know, following kind of their principles, but I think they've moved a little too far, because to watch person after person who wants to serve their state, their local community, you know, and just be kicked off because, you know, a Division I athlete voted in California for a couple of years where she went to college. Well, sorry, those votes don't count. You know.
I wanted to bring up that example exactly, which is in Marion County, it was a challenge to an incumbent Democratic senator by, I mean, she is the daughter of a democratically elected official, is clearly a Democratic Party or an activist who has been heavily involved in the Democratic Party her entire life, basically, has voted in Democratic primaries in other states, and yet, because she doesn't meet a two-primary rule, she doesn't get...
In Indiana.
If in a state that has a severe civic engagement problem, what is the purpose of this other than to even further protect incumbents?
I think you just hit on the solution. I mean, yes, it's problematic, I think, for the reasons you've all articulated. There inevitably will be situations where somebody clearly is not trying to game the system, but is actually just because of life circumstances or any number of things. I mean, I'll never be able to run. I've never voted, not that I was going to run anyway, but I've never voted in a single primary. So I guess anybody who's worried about a future bid for office by me, rest easy, sleep easy tonight.
Unless you find a county chairman who likes you.
You probably couldn't pick one ballot or the other. On one hand,
that's
the
right.
Republican ballot, on the other hand, the Democrat ballot.
I know journalists who go back and forth in election cycles too. But, and there are examples. If this, we've talked about before at the federal level, if this had been in place in New York, Donald Trump would have been disqualified arguably because of his votes in Democratic primaries. He was going back and forth. The problem in trying to get it changed back to, say, one primary is that it does essentially help people who are already there. There's no incentive for incumbents to change it that I can see. So it's not exactly a high priority for them, even though I think democracy and the notion of participation would cry out for a change.
Especially by young people, people of color, underrepresented folks. It really stifles their ability to participate.
Legislation headed to the governor this week could limit debt protections for Hoosiers. Indiana Public Broadcasting's Violet Comber-Weiland reports the legislation would shorten the period of time that Hoosiers have to dispute charges and other issues with their banks.
The bill would limit the state's statute of limitations, or time Hoosiers have to dispute charges, from 6 years to 2 years. Supporters of the bill say it is necessary, as longer statutes of limitations can be used to target financial institutions and cost them money and time in legal cases. Representative Kyle Miller voted yes for the bill, but says he's hesitant because he also heard cases of the statute of limitations affecting consumers.
But I also have talked to multiple financial institutions in my district and beyond that are going through these suits. So either these financial institutions are not sticking to their contract on some mass scale, or we do have lawyers and firms that are going after, that are targeting these financial institutions.
Others testifying against the bill say it would harm consumers with overdraft fees and create other problems with checking and savings accounts.
Elise Shrock, we talk all the time on this show about finding the balance in a piece of legislation. Is this bill balanced?
No, it's not. I think that when we look at the history of this type of legislation, the concession was made in 2021 when it was brought from a 10-year statute of limitations to a 6. Now to go from 6 to 2, who's asking for this? Where did this come from? Because 2 years for a working family that is going through a financial catastrophe, financial hardship, 2 years to get through something like that is not enough time. I mean, trying to sort through a real financial hardship takes years. And to have the statute of limitations in the last couple of years go from 10 to 2 is really over the top.
The banking industry says the 10 to 6 was really just a clarification in law, that it was
agreed to be 6.
It was agreed to be 6.
Community.
Some people were trying to interpret it as 10, and so it was clarified that it was 6. But still, this does go from arguably 10 to definitely 6 to definitely 2. Is that too short a period of time?
How this is playing out in real life is not grandmas with their coin purses being denied their refund on a penalty or a fee. How it's playing out in real life are 3 large plaintiffs' attorney firms, one of them located in Indianapolis, are predatory firms that are going and creating these class actions. They have a long runway to do it in 6 years. Then they go to the banks, which aren't always J.P. Morgan. Sometimes they're North Salem State Bank or a community bank that can't handle a multi-million-dollar settlement, and that's what they go for. They threaten you with the big number, but if you give us the 10 million, we'll forget the 30 million. The attorneys walk away with fees, and everybody gets a coupon in the mail for whatever their share wound up being, which is you've gotten those class action refunds before where you're like, oh, I didn't even know I was in a lawsuit.
Yeah.
And here's your $6. So I mean, the vast majority of these cases are not the family with an economic hardship that now in year 5 has figured out how to get back to the bank, has finally gotten to the bank. It's predatory, and they're targeted by these plaintiffs' attorneys firms.
Stroke that can affect those families. That's rough.
I just don't think they exist.
So that's what it is.
5.
But that's what it is. It's Mike just articulated the problem we are trying to solve here, and it is real. Like, we know that there are banks who are going through this right now who are not the big banks, not the ones that you're thinking of. It's credit union type, smaller community banks. Again, is 6 to 2 the right shift of the pendulum?
It does seem to be an abrupt shift, especially given the earlier reduction in the time. I looked at, as best I could, on a state-by-state basis, what other states do. This, my interpretation, and the data may have been a year old, something may have happened in a session somewhere in another state in the past 12 months, but it appears that 2 would make us the shortest statute of limitations in the country. There's several with 3. Right now, we're pretty much in the middle of the pack. But right now, the shortest, if I read it correctly, is 3. So maybe once we can be number 1. And maybe for all the wrong reasons.
Yeah, I was just going to say, is this an area where we want Indiana to be leading the nation?
Look, I don't know. I will say that, whether you support this bill or that bill, part of it is that there's 2 bills that have moved, and the second bill is similar in that, banks changed rules or whatever in your agreements, and consumers fought back, and they got not 1, but 2 Indiana Supreme Court rulings that said, no, you cannot change the rules within your account without them agreeing to it. So what did they do? There's a second bill that says, as long as you don't, it's basically like, as long as you don't close your account, then you're accepting it.
Yeah, and I think they give you have to provide written notice in 30 days, if I remember that bill correctly.
So the 2 combined sort of, they're clearly on the side of the financial institutions and not the consumers.
All right, time now for viewer feedback. Each week, we post an unscientific online poll question. And this week's question is, should Indiana reduce the time customers can dispute bank charges from 6 years to 2 years? A, yes, or B, no. Last week, we asked you whether Indiana needs a law specifically banning anti-Semitism in higher education. Just 23% of you say yes, 77% say no. I will note that there were more responses than usual to that poll last week. If you'd like to take part in the poll, go to WFYI.org/IWIR and look for the poll. Well, tens of thousands of public pension recipients in Indiana would not get a one-time increase in their benefits this year after a change in a Senate committee this week. The House and Senate have long disagreed over whether to provide retirees with a COLA, annual cost of living adjustment, or a 13th check, an additional benefit between $150 and $450. One bill this session would permanently solve that dispute by providing a 13th check for anyone who retired before July 1st, 2025, and a COLA for everyone who retires on or after that date. But that doesn't solve the issue that in last year's budget, the pension disagreement left retirees with nothing, no COLA or 13th check. The House pushed a bill to make up for that this year, providing a 13th check. Senate Appropriations Committee Chair Ryan Mishler and some of his fellow Republicans on the panel eliminated that provision Thursday.
If you do a 13th check, you're going to prolong the permanent fix.
But Jessica Love, executive director of the Retired Indiana Public Employees Association, says both short-term support and a long-term solution are possible.
Money is not an issue. The budget is not an issue. But retirees barely able to make ends meet or being totally unable to make ends meet is an issue.
Mishler says discussions on the issue will continue. Niki Kelly, you and I have been around this for a little while. The 13th check was almost automatic every single year. Are you surprised at how this is playing out?
I'm shocked that this is the hill that Senate Republicans have said they're going to die on. And honestly, I do think there's some confusion. Senator Liz Brown, who I think is one of the best legislators there is, made a comment in the committee hearing the other day, well, we gave them one last year. And it's like, no, you didn't. This is 2 years in the middle of mass inflation where these retirees have gotten nothing. No 13th check, no COLA. And I understand the desire for a long-term fix, and that's wonderful. I don't understand why you can't do both at one time. There's money in a special fund that they've said, in person and email that said, so long as, basically the economy doesn't crater.
Right, as the
this
actuarial
is
assumptions pan out, right.
And so I don't get what's holding this back.
Ryan Mishler's argument is in order to do the long-term fix that they want, and that everybody seems to agree to in this issue, by the way, is that we're going to set a date that says, okay, if you retire before this date, you're going to get the 13th check. Because people who receive smaller amounts in their pensions, that 13th check is way more valuable than a 1% COLA, which will give them $8 in the course of a year. So basically, starting, and I think the date they landed on in the bill, if I remember, is July 1st, 2025. If you retired before then, you get the 13th check. After that, it's the COLA, and a COLA is more expensive. So in order to keep replenishing this fund, the supplemental reserve account, in order to pay for that, you're going to charge the employers a higher surcharge. And when we're talking about employers, we don't mean big corporations. We mean schools, mostly schools, actually, because the government aren't quite at the level anyway. So his argument is, if we drain $60 million out of it right now to pay the 13th check this year, we've got to build it way higher in order to trigger this long-term fix, and it will push that back, and he's tired of doing that. Is that argument going to hold water with any public pension recipient in the state of Indiana?
I mean, there is a logic to when you spell it out like that, but for a pensioner who's trying to make ends meet and who has been counting on that check and who received it in the past, I don't think logic is the primary consideration. This is more of a compassion issue. It's more of a fairness issue.
It's logic on their part too, but it's a very different logic.
It is a different logic, but I mean, this is a sympathetic audience, and that's the recipients are, and that's why I thought this would be a no-brainer in terms of sure bets with legislation this session, and in all likelihood, they may still get their way. I mean, this is not the end of the road by any means, but keep in mind, for some pensioners, when you're thinking about long-term fixes, the runway isn't unlimited for some pensioners. There will be, sadly, I'm no actuary, but there will sadly be people who, if they don't get the 13 check now, will never receive another penny from the state, simply because, well, I think we all know how biology works. They won't be around.
Ryan Mishler was very quick on yesterday after this happened, when he was talking with myself and another reporter. He was very quick to say, I am one of 150. This is how I feel. And obviously, as the chair of appropriations, he has a little more power than all 149 others. But
he also has a different responsibility in that role. Yeah, it's really nice to go home and just say, hey, we got you that 13th check. So on one hand, I agree with Senator Mishler. His responsibility is, if the goal is to have these increases forever, then this is how we do it. The short-term answer that delays the long-term fix is the popular one, right? So on the other hand, I agree with Bob Cherry. And can we give Bob Cherry a win in his last year? He's been the 13th check guy for like 28 years.
Yeah. That's been one of the issues he's led on in the General Assembly. When we asked Senator Rod Bray this yesterday as well, the Senate President Pro Tem, I asked the question, are you really comfortable with public pension recipients not getting any benefit enhancement for an entire 2-year budget cycle? And he was very quick to say, well, that bill is far from over. Do you think at the end of session we're going to be talking about some piece of legislation that does both the long-term fix and the 13th check this year?
That's kind of what that sounds like. However, I mean, we were talking about this earlier. There's not a lot of time next. There's a week left. So they are.
That's going to feel like a really long time.
I mean, I know that legislative time
short.
is like it's like a time warp. You don't know if it's like going by really quickly or really slowly sometimes. But this is something they're going to have to figure out because, there are folks who may not be paying that much attention to what happens to our legislature, but then when they don't get that 13th check, they're going to be paying attention a lot closer. And it is. We're in the middle of a time when it's hard for people to make ends meet. And this is also cumulative to other pieces of legislation.
And in conference committee, you don't need 5 days, you really need 5 minutes. I mean, anything can happen.
Yeah, that's
Anything can happen.
And to that point,
Anything can happen in
that last week of session, it's just
Anything can happen
it's
in
a
an
jump to the
Indiana
left
week,
and then a
Brandon.
step to the right.
I like the reference.
Indiana's ban on gender-affirming care for transgender youth is now in effect after a federal appeals court lifted a temporary block of the law passed last year by the General Assembly. However, the decision Tuesday does not stop the underlying case, which was granted class action certification in January. A bench trial is tentatively set for April 2025. The law bans medicinal and surgical gender-affirming care for transgender youth in Indiana and prevents providers from aiding and abetting parents seeking that treatment outside of the state. With it in effect, transgender youth no longer have access to puberty blockers. The law originally built in a 6-month window for those on hormone replacement therapies, also known as HRT. The cutoff in the law for those therapies was December 31st, 2023. In response to the order, the ACLU of Indiana, which represents transgender youth, their parents, and gender-affirming care providers in the lawsuit, called it beyond disappointing. John Schwantes, quite frankly, how scary is this situation?
I'm sure it's very scary for families dealing with this. It sort of reminds me in a way, and maybe even the circumstances are more dire and more pronounced than the conversation we just had, where theory and logic are over here, but then you have people trying to live their lives dealing in that case with less money. In this case, it's families trying to deal with profound lifestyle decisions and emotional and health challenges that you would argue that maybe the stay, the more logical thing perhaps, or maybe more compassionate thing would be to allow those treatments to continue while the litigation is argued in court rather than the reverse.
Niki, it feels somewhat akin to the abortion ban in that it was held up for so long that the impact that we all said, hey, this is coming, and then nobody felt it because the courts held it up, and now, boom, it's suddenly here.
Yeah, although because there's allowed to be sort of a taper off period, we won't start getting a lot of those stories maybe for a few months, from people impacted. There are, in terms of numbers, it's not a whole host of people in Indiana, but, there are clearly concerns about whether this will push some minors towards suicide. The next couple months will be, interesting to see.
I just can't imagine being that one parent or more parents right now. I mean, one is heartbreaking enough to have a child who is in the middle of their medical care and then something like this comes down, taper or not, to that fear and having to figure out and ask questions to figure out how to make these decisions for your child. Like, this is heartbreaking. This is, yeah, like you said, it's not theory. In practice, this is a heartbreaking situation and
children,
very
families
scary.
will go out of state, those who have
Well,
this,
this is the
the financial wherewithal.
We talked about the abortion ban potentially driving people out of the state, and we don't know if that's ended up being true or not. But this is one where you might not have a choice. Either you go out of state, your kid might not survive.
And so, why would you want to stay?
Yeah. All right, that's Indiana Week in Review for this week. Our panel is Democrat Elise Shrock, Republican Mike O'Brien, John Schwantes of Indiana Lawmakers, and Niki Kelly of the Indiana Capital Chronicle. You can find Indiana Week in Review's podcast and episodes at WFYI.org/IWIR or on the PBS app. I'm Brandon Smith of Indiana Public Broadcasting. Join us next time, because a lot can happen in an Indiana week.
The opinions expressed are solely those of the panelists. Indiana Week in Review is a WFYI production in association with Indiana's public broadcasting stations.